Hello, I'm Jamaal Jones, and thank you for visiting my YouTube page. If you have any questions or you would like to find out more information about the legal services that I provide, please visit our website at joneshealthlaw.com. Today we're going to discuss physician employment agreements. If you're considering a position as an employee of a hospital, health system, or physician group, it's important to know the basics before you negotiate an employment agreement. These 5 elements that I'm going to discuss are just a starting point. There are a number of other important contract-related considerations to take into account. As a healthcare transactional attorney, I can help you review a specific employment agreement in detail to be sure that it's fair and appropriate and represents your best interests. First, we're going to discuss compensation. Many times physicians want to know, am I being fairly compensated? Will I be able to earn incentive compensation under the terms of the agreement? First, you want to ensure that your base salary is guaranteed for as long as possible without adjustments. For physicians coming directly out of training, this period may only be 1 year, while physicians who are joining a health system as part of a practice sale may be able to negotiate a longer period of guaranteed base salary, let's say 3 to 5 years. You want to find out whether the compensation you're being offered is comparable to that of physicians with similar skills and experience in your region. Survey reports on the physician compensation are available on various different websites to help you determine how much family physicians or any other type of physician earn in your area. You can also ask employed colleagues who are in similar practice situations and how they are compensated. If an employer offers a base salary plus incentive compensation, look closely at how you would qualify for incentive payments and how they're calculated. Many incentive models are still based on collections or work-related value units. However, these models are evolving to support higher quality, better coordination of care, and improved efficiency through clinical integration and accountable care organizations. If you will be eligible for meaningful use incentive payments and other types of bonus money that may be available, get specific information about the criteria the employer will use to disperse these payments. Specific requirements regarding all the activities and metrics, i.e. collections, productivity, quality, meaningful use, that will affect your compensation should be included in the employment agreement or in an established written policy that is applicable to all similarly situated physician employees, not subject to the employer's discretion. Consider what benchmarks you'll be measured against and how data will be collected and submitted, and ensure that the benchmarks are stipulated in the agreement. Let's move on to number 2. Benefits. What benefits does the employer offer? Should I ask for additional benefits? Employers typically offer health insurance for the physician employee and possibly for family members at an additional cost. License fees, medical staff dues, and a stipend for continuing medical education. Many employers also provide a retirement plan. In general, hospitals and health system employers offer a better range of benefits and more retirement options than private practices. It's not unusual for physician employees to get 3 to 4 weeks of paid vacation and CME time. It's less common for employers to offer paid sick leave. More employers are combining vacation, CME time, and sick leave into a paid time off concept. Be sure that your employment agreement specifies the amount of paid time off to which you're entitled. If not, changes to your employer's leave policy could reduce your benefits without your consent. If your compensation is based in part on productivity, you should analyze how your income may be affected when you take paid time off. Most employers pay for malpractice insurance. As an employee, it's preferable to have occurrence-based coverage for incidents that happen during the coverage year, regardless of when a claim is filed. That's very important. If you have claims made coverage, which is for claims filed during the coverage year, you'll need a reporting endorsement or tail coverage when your employment ends. This covers incidents that happen during employment but aren't litigated until the employment ends. If the employer offers a claims made policy, your employment agreement should specify whether the employer will pay for part or all of your tail coverage upon termination of employment. If you're considering employment or position in a different area, ask the employer whether a moving expense allowance is available. Third, schedule and call. What are my call and coverage obligations? Employers often leave scheduling provisions loose so that physician employees have the flexibility to deal with the needs of their patients and the practice. Be open about your schedule expectations to ensure that they align with the employer's requirements and needs. If the employer makes any promises about your schedule, i.e., or for example, you won't have to work more than one night per week or one Sunday per month, you have a flexible schedule, so on and so forth, try to incorporate the specifics into an employment agreement. Call and coverage obligations should be spelled out in the employment agreement. Be sure that your call responsibilities are not more burdensome than other family physicians or any other physicians employed under similar terms. Also, find out whether the employer offers compensation for taking call, which usually only occurs for taking additional call beyond that which you're already required to provide. If you're only working part-time, be specific about your schedule in the employment agreement, especially if you're paid on a salaried basis. This prevents the employer from taking advantage of you by requiring you to work more hours than agreed upon. Fourth, terms and termination. What is the actual term of the employment agreement and what are the termination provisions? Many employers, especially physician groups, include a without cause termination provision in the employment agreement. This allows you or the employer to terminate your employment without cause or any reason whatsoever. A notice provision that requires written notice 30 to 90 days prior to termination is typical. Almost all physician employment agreements allow the employer to terminate for cause. Be sure the agreement requires your employer to give you written notice of the cause for termination and an opportunity to fix alleged breaches or deficiencies within a reasonable period of time, typically 5 to 30 days. Keep in mind that termination provisions set the term of agreement, regardless of the stated term. If you or the employer can terminate the agreement without cause, the actual term of the agreement is the length of the notice period, 30 to 90 days. Some hospitals and health systems will guarantee a minimum 1-year term. Be aware that if you agree to this, you're contractually obligated to stay for the full term. Fifth, restrictive covenants. If my employment ends, will I be able to practice in this area? This is an area that's often overlooked by young physicians. Some states do not permit restrictive covenants, or they limit an employer's ability to enforce them. However, many states do enforce them, even if there are limits proposed or imposed by state law. In general, these states require that restrictive covenants must be limited in duration and geographic scope to reasonably protect the employer's interest against competition. More restrictive covenants last for 1 to 2 years following termination of employment. A reasonable geographic radius for a restrictive covenant depends on where you practice. A restriction of 25 miles might be appropriate in a rural area, whereas a 1-mile radius might be enforced in an urban setting. Occasionally, a restrictive covenant might be enforced for an entire county. So, for example, a physician might be prohibited from practicing in Kings County or Leon County or Miami-Dade County. Ask if the employer will agree to limit the instances in which the restrictive covenant is enforced. For example, the employment agreement could specify that the restrictive covenant will not be enforced if you terminate your employment for cause. No solicitation provisions go hand in hand with restrictive covenants. States that don't enforce restrictive covenants often allow provisions that prevent you from soliciting former patients, employees, and referral sources after your employment ends. Thank you for taking the time to view this YouTube video on physician employment agreements. I hope that it was informative. If you have any other questions or concerns about physician employment agreements or any health law related issues, please feel free to contact me. You can visit my website at joneshealthlaw.com, or you can call me directly at 917-912-8108. Our offices are located in Miami, Florida. Thank you very much for your time.